Hi, I'm attorney Gregory Dell, and I want to talk to you about Dearborn National Insurance Company, and specifically I want to talk about short-term and long-term disability insurance claims. Now, a lot of people with Dearborn National are employees or of the University of Texas, and Dearborn National offers and administers all of the disability insurance benefits for the University of Texas employees. So that's a pretty large bulk of business for them, and the advantage for people who have these Dearborn National policies is that those policies are ERISA exempt, which means that you're not going to be governed by this horrible federal law of ERISA, and you'd be able to have a jury trial, your day in court, and you're not necessarily subject to having to do these ERISA appeals, which is a significant benefit. However, Dearborn National is a very large disability insurance company. They do well over $1.3 billion in revenue and have almost $4 billion in assets under management. So they're a well-established insurance company that's really been around for a while. And they have a fairly extensive litigation, lawsuit experience in the disability insurance world. We've handled many claims against Dearborn National, and I'm very familiar with all of the lawsuits that have been filed against them. Now, Dearborn National in their disability policies offers a ONOC definition of disability, which means unable to perform the material duties of your occupation. And then they often offer that definition for a period of 24 months, at which time they'll switch to unable to perform the duties of any gainful occupation, which means that it's a totally different change of definition, and it determines whether or not you could do any type of job for which you have experience, education, and training. Some of their policies have an income component where you must also be able to earn up to 60% of what you were previously earning in order to qualify for disability. Now, all of the policies with Dearborn National are going to require you to apply for Social Security disability, especially if there's this change of definition from own occupation to any occupation. So applying for Social Security disability becomes an important factor for Dearborn, because what they want to do is get you approved. If you get approved for Social Security disability, they want to offset your monthly benefit by the amount that you receive from Social Security disability. Also keep in mind that if you have minor children under the age of 18, you're also eligible for a Social Security benefit for your child, and Dearborn's also going to look to offset the amount that you receive on behalf of your child. Now, with Dearborn National, they also have some limitations in their policy, and specifically, they have what's called a mental nervous limitation. Usually it's for a period of 12 or 24 months, which means that if you're disabled by any type of mental nervous condition, usually as your primary condition, then they're not going to pay you benefits for more than 2 years. There has been some extensive litigation against Dearborn National over this mental nervous limitation because of the fact that very often people have a psychiatric or mental disorder. However, they also have a physical condition. And in most cases, the physical condition came before the mental condition, which means that the mental condition is an exacerbation or secondary to the physical condition. And if that's the situation you're in, you may very well have a very strong claim to prove that you're not disabled primarily by a mental condition, but you're disabled by the physical condition. And that's something that we've worked on with tons of claimants to get them past that 24-month limitation. There's also been claims where we've worked on where we've been able to prove that a mental condition is actually a brain injury and not just a psychiatric disorder. And a brain injury is a physical condition and not a mental condition. So that's another avenue that we can look into for you as well. Now, when it comes to appeals, again, we talked about the fact that their policies are primarily governed by ERISA unless you are a government employee or an employee of a public university such as the University of Texas, then you would be exempt from ERISA. But the vast majority of the Dearborn claims are governed by ERISA. And if your claim has been denied, then the process that has to happen is immediately we have to request a copy of your claim file. The claim file is required to be given to you under the law, and that's going to compose of everything that Dearborn National has done to review your file. So it's not like one of these other cases where they get to hide the ball on information, not give you copies of their medical reviews, not give you copies of video surveillance. Anything that they did, email communications, everything is in that claim file. So that's the first step. We get that claim file, we immediately review it. The most important thing we're looking for in there is their medical reviews to see what did their doctor say that disagrees with your doctor's. When we receive that information, we're going to work with you and your doctors to determine what additional medical information we need to obtain in order to prove that you're not able to do the duties of your occupation or any gainful occupation if you're in a situation where your definition of disability has switched from the ONOC to the any occupation. The other thing that we're going to look for very closely in your claim file is what type of investigation has Dearborn National done with regard to your activities. Often, Dearborn National is looking for inconsistencies between your daily life activities and what you told your doctors. So that would be examples of their profiling your social media. They're looking through your Facebook, they're looking at your LinkedIn, they're looking at your Instagram. Any of those avenues that you may use, they want to see what you're doing that may be different. The other big thing that they'll do is they'll run video surveillance of you. They'll follow you going to the grocery store, taking your kids somewhere, going to a doctor's appointment, walking outside your house to take the garbage cans in. Whatever it is, they'll hire someone to follow you for 2, 3, or 4 days, and they want to see if you're doing any activities, again, that are inconsistent with what you told your doctor. The other aspect that's important on the appeal, if you've been denied, is we have to look at how they defined your occupation. And did they truly consider the duties of your occupation? And even if it is one of what's called this national economy standard, where they say, we don't consider how you perform the duties for your employer, we're going to look at how it was performed in the national economy. We're still going to work with our vocational experts and make a determination as to whether or not they appropriately defined how your job was being performed in the national economy. We have 180 days to do an appeal from the date that you're denied, and it really takes the majority of almost all that time because it takes time to get all of your medical records, to then get additional testing done, to get in touch with all of your doctors, to get your doctors to reply to the reports from Dearborn National, and then put something together that's very extensive in response to Dearborn National. The reason this is so important is because you only get one bite of the apple with an ERISA appeal. That means that if something were to happen to you the day after Dearborn makes their final decision, that evidence is inadmissible. We have to get everything in. So we have to do every single thing we can during your appeal to give you the best opportunity to win your claim. The other aspect that happens if you are to lose your appeal is then we get into litigation. And we've litigated several cases against Dearborn National, and depending again whether or not your claim is governed by ERISA is going to determine the strengths and weaknesses of your claim. If it's non-ERISA, a whole other animal, we're going to get into a jury trial and the opportunity for you to have your day in court. Again, the primary, most of these cases are governed by ERISA. And when it comes to litigation, it's going to matter whether or not your policy has a discretionary clause. If there is a discretionary clause, that means we have to determine whether or not Dearborn acted unreasonably. If we can prove that they acted unreasonably in the review of your claim, then we win. If we can't prove that they acted unreasonably, then we lose. Now, I'm really minimizing that situation. However, it's a very high burden to prove that the insurance company acted unreasonably, and the majority of the case law around the country is pro-insurance company. Depending upon what circuit court applies to you, which depends upon what state you live in, and we've litigated in almost every state across the country, that will determine what the case law is that applies to your case. So if you have a claim with Dearborn, whether it's an appeal, whether it's a lawsuit because you've been denied and it has to be filed, or you're even considering filing, what we need is a copy of your policy. We will immediately review your policy, and we're going to provide you with a free consultation with one of our lawyers. We're going to look at the policy if you're just applying and let you know if we think it's a policy you could collect on. If you've been denied and you need an appeal or a lawsuit, we're going to review the denial letter, and we're going to let you know what we think our strategy would be in order for you to get your benefits reinstated or for you to win a lawsuit and possibly end up with a lump sum settlement. Very often, a lot of the Dearborn National lawsuits result in a lump sum settlement, which means They will offer you a one-time payment in which they're basically buying out your policy. You agree to surrender the policy and you get a lump sum of money and you don't get any additional benefits at all. This can potentially be a very good resolution for you because going to trial is a very high-risk situation where if you lose, you're left with nothing. So what happens very often is a reasonable offer is made. The amount is not necessarily what you want. It's more than what the insurance company wants to pay, but we're able to reach a resolution that gets you some kind of security of knowing that you're going to get paid something on this policy. So we'd love the opportunity to discuss your options with you. Feel free to call myself or any of our team of disability lawyers. We'll answer your call right away, and we look forward to the opportunity to speak with you.